let me turn to the introduction. What was the background to the FCA test case? Well, not really beginning at the beginning, but almost at the end. On the 15th of January this year, the Supreme Court handed down its judgment on the Financial Conduct Authority FCA test case, which, as I've already indicated, FCA and Arch Insurance and others. And it deals with the non-damage clauses which extended the typical coverage under business interruption insurance. For the expeditious process and disposal of the case, the parties to the litigation entered into a framework agreement under which, and I quote from the Supreme Court's judgment, the aim of the proceedings was to achieve the maximum clarity possible for the maximum number of policyholders and their insurers, consistent with the need for expedition and proportionality. The approach taken has been to consider a representative sample of standard form business interruption policies in the light of agreed and assumed facts. It is therefore immediately apparent that the whole conduct of the litigation comprised and included a number of compromises. The need to find a balance between maximum coverage, maximum clarity, speed, and proportionality. The need not only to agree, but also to assume facts. The extent to which such assumptions were made for the purpose of the test case, and only for the purpose of the test case, may not be totally clear. In other words, could facts assumed for the purpose of establishing the legal principles be revisited and put in issue for the purpose of determining particular issues of liability and quantum on specific cases in the light of those general principles now determined? Moreover, as the Supreme Court went on to say, it's estimated that in addition to the particular policies chosen for the test case, some 700 types of policies across 60 different insurers and 370,000 policyholders could potentially be affected by the outcome of the litigation. In February, the Association of British Insurers estimated at £2 billion the value of business interruption claims incurred in 2020 due to the COVID pandemic. Now, these figures give some indication of the magnitude of repercussions from this litigation. Should also be noted that not all the findings of the divisional court at first instance were subject to the appeal to the Supreme Court. Yet the Supreme Court departed from the reasoning of the divisional court in important respects, notably with regard to causation. Do these changes of judicial reasoning also impact on aspects of the test case that were not subject of appeal? And if the Supreme Court's reasoning impacts on non-appealed aspects of the case, as well as those aspects that were comprised within the appeal, what are the practical implications of that being so? Nor, indeed, did the Supreme Court speak consistently with one voice. Lord Briggs, with whom Lord Hodge agreed with the conclusions of the rest of the Supreme Court, the majority, but departed from their reasoning on one major and one minor point. As Lord Briggs summarised it, the practical effect is that all of the insuring clauses which are in issue in the appeal will provide cover for business interruption caused by the COVID pandemic, and the trends clause will not cut it down in the calculation of the amounts payable. So with these major and minor points noted, we really have what might appear to be a relatively straightforward formulation of the relevant question. What is the nature of the cover of these policies? And broad agreement on the answer, namely that the insurers are on the hook and are liable under the policies. what could possibly be easier? Well, while the start and the end are tolerably clear, I'm afraid the bit in the middle isn't, and it's a substantial and complex bit. Secondly, we might, of course, only be in the foothills of scaling the Everest of complexity. Stating legal principles is one thing. Applying them to particular cases, of which there are, as you'll recall, over 370,000, is likely to be quite another matter. So, having set the scene, I'm now going to ask Lee to begin by telling us in a little bit more detail what the divisional court decided. Lee.
Thank you, Michael. Good afternoon, everyone. In the foothills of scaling the Everest of complexity. Wow. Well, if the mountain won't come to Michael and Muhammad's nowhere to be found, then I suppose it falls to Muggins here to go to the mountain and begin the ascent. The first thing I'd say is that Michael wasn't exaggerating. This was or is a fiendishly complicated piece of litigation. There were, as you've heard, 21 specimen or lead policy types from 8 insurers, the wordings from which were grouped into 3 categories. But of course, as you can imagine, even within the same group, not all the wordings are the same. And so subtle differences in the language used will make a critical difference to the court's relevant factual findings. So just because there's a finding in respect of, for example, policy RSA 1, doesn't mean that the same is true of, for example, MS Amblin 2. So 3 groups of wordings: disease clauses, prevention of access or public authority clauses, and hybrid clauses. Typically, disease clauses were structured as follows. They provided cover for loss resulting from interruption or interference with the business. Query, of course, whether those 2 words have different effects. Following or arising from or as a result of, and there will, you might not be surprised to know, some significant debate about the meaning of the word following in this context. Number 3, any notifiable disease, any occurrence of notifiable disease arising from any human infectious or contagious disease manifested by any person. So again, there's some consideration about whether the word occurrence and the word manifestation amount to the same thing. And then finally, you tend to find in the disease clauses some geographical restriction, specifically within a 25-mile radius, a 1-mile radius, or alternatively within the vicinity of the premises or the insured location. Now, you'll be surprised, I know, to hear that the insurers sought to minimize the scope of the cover and the quantum of damages ultimately payable. And they did that essentially by seeking to contend that the cover they provided was for the local occurrence of a notifiable disease. What they argued at the divisional court was if the disease was spread over a wider area, then it was only the effects of the local outbreak that were covered, and indeed only where they could be distinguished from the wider, i.e. national effects. So their approach to causation, the insurers, was to say, well, if but for the local outbreak, there would have been the same interruption or interference because of the presence of COVID-19 nationally anyway, then there was no cover. The FCA opposed this, and the divisional court, at least as far as this aspect of things was concerned, agreed with the FCA. What they said in summary was, and we're going to have to summarize it, was outbreak means occurrence, whether diagnosed or symptomatic or not, and that what the word following meant was it denoted a requirement of proximate causation, and that would be met when there was a national response to the widespread outbreak of a disease. So what they said essentially was that causation meant that the proximate cause of the business interruption was the notifiable disease of which the individual outbreaks formed individual parts. or alternatively, that each of the individual occurrences were a separate but effective cause of the national actions. What the divisional court said was that unless it was expressly stated otherwise, what was being insured against was the disease that had come near the premises rather than specific local occurrences of it. They said that that was a reading that was in keeping with the nature of insurance and the nature of notifiable diseases, which of course were capable of widespread dissemination. And they have, of course, had a close look at SARS. All of these diseases, of course, by their nature, are going to engage a response by national bodies, not just local bodies. And so what they said in relation to causation was that cases within the relevant policy area were not independent of and a separate cause from cases outside the policy area. Within this context, they had a look at the meaning of the word vicinity, which was defined in a particular policy, RSA 4, as an area surrounding or adjacent to an insured location in which events that occur within such area would be reasonably expected to have an impact on the insured and the insured's business. And what they said about the meaning of the word vicinity was that they said, well, this can be construed in the context of the disease cause as encompassing the whole of England and Wales. And they said that this wide reading, this approach, would avoid the anomalous results that the insurers were contending for. Now, very quickly, in relation to the other two categories of clauses, prevention of access and hybrid, there was a much more restrictive approach taken. Prevention of access clause is where you're saying that there's been a cover for loss resulting from prevention or denial or hindrance of access to the premises due to either actions or advice or restrictions, and we'll come in a moment to the difference between those, imposed by order of a government or local authority or other body due to an emergency or in the relevant area. Now, what the court said here was that emergency in the vicinity, etc., these were requirements that connoted something specific happening at a particular time and in the local area. And so what they said was that these clauses were intended to provide narrow, localized cover. And so effectively, insureds would have to show that the business interruption was caused by the disease in the local policy area, which of course, as one can imagine, outside the notion of the local lockdown is going to be fairly difficult. As far as restrictions, they said had to be mandatory. And so what that meant was that announcements by the government about such things as stay at home or keep a distance, they were characterized as advice and not mandatory instructions. An action that imposed a restriction, they said, had to be something that carried the force of law behind it. The hybrid wordings, just very briefly, were essentially a blend of the disease wordings and the prevention of access and public authority wordings. And essentially what happened was the divisional court took a similar approach to the disease part of the wording and read that quite widely, but then took the same restricted approach to the other part of the clauses that mirrored effectively the prevention of access wordings. That's about as brief a summary as I could give. So having begun the ascent of Michael's Everest, I'm going to see if I can throw the rope to Celso. Celso, can you hear me up there? What did the Supreme Court decide in relation to causation?
Yes, what did the Supreme Court decide in relation to causation? Well, the first thing to remember is what Michael said, that not all the issues were, not all the extensions were appealed. About half of them were appealed and the other half were not appealed. Most of the ones that were appealed were the hybrid and disease clauses. So the great question for the future is what happens with the extensions, particularly the prevention of access extensions that were not appealed, but now they are subject to this new reasoning that was handed down by the Supreme Court. After the decision of High Court, permission was obtained for a leapfrog appeal, and on causation, the issue with the most wide-ranging impact on all types of insurance policies, and also obviously on the extensions that were not appealed, is the what some commentators, regard as the restatement of the proximate cause test and the possible abandonment of the previous common sense approach to the determination of the predominant cause of the loss. And this is what the Supreme Court held in paragraph 168, and I quote, that the question whether the occurrence of such a peril was in either case the proximate or efficient cause of the loss involves the making of a judgment as to whether it made the loss inevitable in the ordinary course of events. So this is a slight modulation, maybe, or a new test of predominant cause, of proximate cause, that involves the loss being inevitable in the ordinary course of events. And in the future, these words are going to be, analyzed and reviewed and re-examined by many courts in the UK. And the Supreme Court went on to say that in the cases where neither the insured or uninsured cause alone made the loss inevitable, so did not satisfy the but-for test of causation, nothing precludes an insured peril that in combination with many other similar uninsured events brings about the loss from being regarded as a proximate cause of the loss, even if the occurrence of the insured peril is neither necessary nor sufficient to bring about the loss by itself. So if I can pause here and put things into context, the main defense in the appeal of insurers was that because you couldn't say that the losses occurred just due to the effect of COVID-19 within the 25-mile radius restrictions, because they would have occurred anyway due to the restrictions, nationwide restrictions resulting from the COVID-19 pandemic effects outside the 25-mile radius. So, neither only the 25-mile radius, within the 25-mile radius occurrence, nor the outside the 25-mile radius occurrence alone would satisfy the but-for test of causation. And that was a problem that policyholders had to overcome, or the FCA had to overcome, to show that there was coverage. And in the end, the Supreme Court didn't agree with the High Court's combined peril approach and went for this broader proximate cause test approach, where even if neither concurrent losses could satisfy the but-for test of causation, in combination, they could satisfy the proximate test, and therefore there was coverage. And as a result, the Supreme Court held that in relation to the disease and hybrid clauses, which had a radius requirement, there was coverage for business interruption losses, so long as there was at least one case of COVID-19 after the 5th of March 2020, when it became a notifiable disease in the UK within a 25-mile radius. But the crucial point here is that the Supreme Court's understanding was that the parties cannot have intended that the cases outside the 25-mile radius could be used as causes of loss to exclude or to operate as an exclusion of the losses caused by the cases inside the radius, which were covered losses. But now, moving on to the other issues, Michael, what did the Supreme Court decide in relation to the other issues appealed?
Also, thank you very much for asking me to deal with some further aspects of the UK Supreme Court judgment. For present purposes, I'm going to confine myself to three aspects of the judgment. What the UK Supreme Court said about restrictions imposed, what it said and its comments on inability to use, and thirdly, a little bit more broadly, what was said about so-called trends clauses and related to that pre-trigger losses. Restrictions imposed were discussed by the Supreme Court at paragraphs 125 to 128 of the majority judgment. Now, essentially, the question here is whether the general regulations issued by the government on the 26th of March 2020 were capable of being a restriction imposed within a public authority clause for the purpose of business interruption cover, and whether it therefore triggered the policy. The insurers, in particular Hiscox, argued that a restriction imposed needed to be directed to the policyholder or to its use of the insured premises. So the insurers were arguing for a very narrow analysis and approach. The FCA, however, argued that the clause was not so limited. Both at the divisional court level and at the Supreme Court level, the insurer's argument was rejected. It was rejected by the divisional court, basing itself on an analogy of a police cordon thrown around the premises in question, resulting in complete inability to use those premises, even though the imposition of the cordon had nothing to do with either the policyholder or the premises. Assume a murder in the immediate vicinity of the premises. And arguments were put against that. They're summarized in the Supreme Court judgment. But despite cogent arguments to the contrary, the UK Supreme Court was unpersuaded, observing that the words restrictions imposed were general and unqualified, and thus, whatever might be the case ordinarily, the limitations urged by the insurers were rejected, and the Supreme Court acknowledged the force of the cordon analogy. Let me turn now to inability to use. That's discussed in the immediately following paragraphs of the Supreme Court, paragraphs 129 to 145. And in this regard, the divisional court had been quite strict. It held that inability to use required a complete inability to use, save for a de minimis exception. The FCA and the insured interveners felt that this was too strict a requirement. And interestingly, the Supreme Court began by agreeing with the court below that, quote, an inability of use has to be established, not an impairment or hindrance of use. But having agreed up till that point with the Supreme Court, with the divisional court, the Supreme Court went on to say that, on the other hand, we do not accept that the inability has to be an inability to use any part of the premises for any business purpose. So they cut down the scope of the divisional court's reasoning. And the essential finding of the Supreme Court in this regard is at paragraph 137. We consider that the requirement is satisfied either if the policyholder is unable to use the premises for a discrete part of its business activities, or if it is unable to use a discrete part of its premises for its, i.e., whole business activities. In both those situations, there is a complete inability of use. In the first situation, there is a complete inability to carry on a discrete business activity. In the second situation, there is a complete inability to use a discrete part of the business premises. To that extent, the question, the Supreme Court says, is indeed binary. But interestingly, the Supreme Court also went on to say and stress that this aspect is heavily fact dependent. So you can rest assured that there is plenty of scope for further exploration of this aspect in the course of further litigation. Let me turn to trends clauses and pre-trigger losses, discussed respectively later in the Supreme Court judgment at paragraphs 251 to 288, and then following at 289 to 296. Now, a trends clause, as you'll be familiar, is one under which the business interruption loss is quantified by reference to the performance that the business would have enjoyed had the peril not occurred, but it's calculated by reference to a previous trading period as a comparator to establish a standard turnover or standard revenue from which a gross rate of profit is then calculated. In approaching trends clauses, the Supreme Court set out some important interpretation points, and they are as follows. Trends clauses quantify loss, and therefore, and the Supreme Court drew this as an express distinction, they do not delineate the scope of indemnity. Trends clauses should therefore be construed consistently with insuring clauses and should not take away cover provided by insuring clauses unless there are express words which have that effect and only that effect. So thus, essentially, if an insuring clause provides cover, the court will stretch every sinew to avoid the trends clause cutting it down. And the essential question, therefore, is what is the relevant counterfactual? And here, the Supreme Court held that unless there are clear words to the contrary, the aim is to arrive at the result that would have been achieved but for the insured perils and circumstances arising out of the same underlying or originating cause. And those additional words are very important because they widen the scope in relation to recovery. And the Supreme Court justified its conclusion by reference to a historic analysis and to US case law. But they said and stressed again that it's only those parts of the business which are interrupted. And they gave an example of a footwear shop, which also sold online, as to partial business interruption. Now, back to the importance of those words, particularly in regard to pre-trigger losses. Now, here, the Supreme Court departed from the divisional court by saying that it must be assumed that any measurable downturn caused by the pandemic, but caused before cover had been triggered, would not, must be assumed that it would not have continued for the purpose of the trends clause and the comparison of a previous section of revenue and turnover. In other words, if the comparator contains a dip as a result of a loss of earnings, loss of revenue attributable to COVID, but before insurance cover kicked in, that downturn should not be taken into account. And here the Supreme Court differed from the divisional court. Why did they do that? Well, they said it should be left out of account because the trends or circumstances for which adjustment may be made do not include the trends and circumstances caused by the insured peril or its underlying or originating cause. So you can see how those words come back in this context, and including such a downturn in the calculation would be to refuse to indemnify the policyholder for loss proximately caused by the insured peril. That's the conclusion of the Supreme Court at paragraph 295. And having dealt with that aspect, I now pass over to Lee to tell us a little bit more about what remains in draft declarations which followed on from the divisional court and why it's important, why these declarations and the order is important for future disputes. Lee.
Well, thank you, Michael. The short answer to what remains outstanding in the draft declarations order is a lot. There are 30 pages of declarations. You can find them on the FCA website. They're double-spaced, but they do run to 30 pages. And it's very simple. When you look over it, where the font is in the ordinary black, that means it's agreed. And where the text is in red, that's what the FCA is proposing. And where it's in blue, that's what the insurers propose. Suffice to say, I thought I'd print myself out a copy this morning just in case I needed one. And I did it on a black and white only printer. And the resulting document is pretty much useless because, well, all one can say is that it is a tribute to the fire in the bellies of the barristers concerned that even though the opinions of the Supreme Court have been handed down, running to itself 115 pages, so much remains so hotly contested. I'm going to focus on two of the key things that are clearly very hotly contested. The first is what amounts to restrictions imposed. Now, you'll recall that in both the prevention of access and similar clauses, and also the hybrid clauses, there was reference to actions or advice or restrictions imposed by a government or other local authority. And so in the hybrid wordings, there was this reference to restrictions imposed. So it's obviously a very critical issue to know what amounts to a restriction imposed. There are a small number of events where it's agreed by the parties this either does or is capable of amounting to a restriction imposed. But what you then see is huge swathes of disagreement, the parties perhaps marking out their territory in time-honoured fashion. And it's all down to the language. So what you have is where the FCA is describing the events, they describe them as an instruction. So they'll be saying the following amounted or was capable of amounting to restrictions imposed, the Prime Minister's instruction, ... But where the insurers disagree, you'll have an almost identical clause proposed by them, which will read, the following did not amount to restrictions imposed. And what they'll do is, instead of using the word instruction to describe what happened, they'll use words like request, guidance, or statement. So for example, Declaration 17.4b. The following, say the insurers, did not amount to restrictions imposed. The Prime Minister's request to stay at home and request not to gather in public, socially, or at mass gatherings on the 16th of March 2020. The government's guidance on 2-metre distancing. The Prime Minister's request regarding 2-metre distancing. Public Health England's guidance. The Prime Minister's statement to stay at home on the 23rd of March. So all of these things being categorised, described in such a way that would lead to the conclusion that they're not restrictions imposed for these purposes. The second bit that's particularly interesting, and you may feel entertaining, is to do with the implications of the findings in relation to the definition of a manifestation or occurrence of a disease. You'll recall that from earlier that these policies often stipulate that there had to be an occurrence or a manifestation of COVID-19 within a specified radius. One of the parts of the declaration that is agreed by everybody, common ground, is that COVID-19 was manifested within, for example, a radius of 25 miles, whenever a person displayed symptoms of or was diagnosed with COVID-19 and was or were within a 25-mile radius. Pretty simple, you might think. You're within the radius and you've either been diagnosed or you're displaying the symptoms of COVID-19. But, say the insurers, they contend there was no occurrence or manifestation within a given radius merely by reason of the fact that a person travelled through that geographical area and had no contact with anyone living in the area. So clearly what they're looking to do is to shut out a claim where they can say, well, if all that's happened is somebody has travelled through here without making contact with anybody, we should disregard that. And of course, you may wonder, well, if that's something to be disregarded, what other types of what would otherwise be occurrences or manifestations should be disregarded? Anyway, suffice to say, as far as in answer to Michael's question, well, there's a lot that remains outstanding in the draft declarations. It's not just those two very important aspects, but those are two of them. So sticking with the declarations, Celso, what about the trends clauses? What's been left undecided in relation to those?
Yes, Lee, that is probably the widest ranging aspect together with causation. And I've been asked to remind everybody to, please send your questions to us via the Q&A facility, and we will deal with them at the end. I'm not going to repeat what Michael very expertly exposed in relation to the Orient Express Hotel case and how it was overruled by the Supreme Court. Just focusing on the draft declarations, because all these disputed areas in the draft declarations is basically where the rubber meets the road, so to speak, for future disputes. The reason why the declarations are not agreed is because there is so much uncertainty and there will be so much effect on the exclusions the extensions that were not appealed and similar non-damage extensions. And you can see, as regards the trends clause in paragraph 11.2 of the draft declarations, the main issue in dispute there is whether in the counterfactual or the hypothetical loss scenario, do you take into account, as part of the circumstances of the business, no other consequences of COVID-19 as it is submitted by the FCA, or do you only disregard those circumstances which operate concurrently with the insured peril, which is a narrower scope as submitted by insurers. So the discussion is as to the scope of the hypothetical scenario for determination, the quantification of the loss. With the FCA trying to have a broad interpretation that any consequences of COVID-19 cannot be part of the trends, only those that are concurrent, and not only those that are concurrent, but any consequences. And the FCA is saying that only those circumstances that are concurrent with the insured peril with COVID-19. So there's a kind of a time restriction that the insurers are seeking to impose, whereas the FCA is trying to advocate a broader interpretation, understandably. And if anybody thinks, I'll just finish with this point, if anybody thinks that this was not anticipated, after the Orient Express Hotel, in the LMA, the Lloyd's Market Association, issued two forms, LMA 3109 and LMA 3110, in October 2012, entitled Power Utilities, Property Damage and Business Interruption Wordings, trying to clarify this problem by saying that the circumstances will be taken into account in the calculation, save to the extent to which the market for the business and its competitors was generally impacted by the underlying cause of the direct physical loss or physical damage. But we will have to see, wait and see what the Supreme Court determines when the declarations come out. It was promised, according to the FCA website, on the 30th of April. They said that it was going to be there was going to be a hearing sometime in May. We are now in June, and there's still no definition of what the declarations will be. So we're going to have to wait a little bit longer. But Michael, I have a question for you to continue the analysis of the outstanding issues. In your view, what are the outstanding issues in relation to causation?
Well, thank you, Salsa. That's a very interesting question, because, of course, it has to be recalled, I think, in this context, that the whole test case was brought as a result of a framework agreement. Not all the policies which are at issue in the overall COVID problem were comprised within the test case before the divisional court, and not everything before the divisional court was appealed to the Supreme Court. On top of which, the Supreme Court, as you've indicated, changed the approach to causation. So it does seem to me that this will, or certainly at least might, cause some considerable problems, and two immediately spring to mind. As to causation in relation to policies outside the framework agreement, and also as regards policies within the framework agreement, but which have not been appealed, but where the proper approach to causation has now been really quite radically altered by the Supreme Court. Let's take one example, and it's really an example building on something that Lee has already spoken about when he talked about the in the vicinity cases considered by the divisional court. Now, there are also business interruption extensions which aren't on the basis of in the vicinity, but are on the basis of at the premises, so even more focused. Let's take those cases, those policies, as an example, another example of non-damage extension clause. Those policies were not even within the framework agreement. But of course, the divisional court did, as Lee has pointed out, express a view on the in the vicinity clauses. Now, is there a read across? But then when one hears about the breadth of the definition given to the word vicinity, maybe there isn't. And here one has a precision in the formulation of one type of policy, the at the premises policy, and an elasticity, which certainly was stretched elastically by the divisional court in talking and discussing in the vicinity. And here I think it's also important to recall what Celso was saying on causation, because the divisional court essentially required a close causal nexus between the localized occurrence of the illness and the emergency, danger, incident, injury, which was caused, i.e. the divisional court focused on the need for a local occurrence causing governmental action, rather than focusing on a bigger picture in relation to the nationwide outbreak. Now, of course, it's very difficult to establish that governmental action was as a result of a local occurrence. Of course, the Supreme Court finds that one occurrence of COVID within a limitation restriction, whether it's 25 miles, 1 mile in the vicinity, etc., is sufficient to trigger liability to indemnify in combination, i.e. even if the nationwide outbreak also caused the government to react and the government's action. So there is perhaps here very clearly an unresolved tension between the relatively restricted approach to this aspect that the divisional court adopted under the in the vicinity clauses and the broader approach to causation taken by the Supreme Court. And in this regard, Lee has also spoken about the declarations made by the divisional court and which are still, as Celso was saying, in the process of consideration by the Supreme Court. But if one goes back to Declaration 22 in the High Court, in the divisional court, that relates to an AOCA clause, an action of competent authorities clause, prevention of access. And that talks about causation in the following terms. The cause of the imposition of restrictions was the national COVID pandemic, which was not an incident being the triggering word within this particular policy provision. Then it goes on, the FCA cannot establish that the national restrictions imposed in response to COVID-19 were caused by an incident. So the FCA is having difficulties in bringing the circumstances within the clause as the divisional court sees it. And then it goes on, even if the presence of a person with COVID-19 within the radius or the vicinity could be said to be an incident, which it cannot be said that any such localized incident of COVID-19 caused the imposition by the government of national restrictions in response to COVID-19. So that's a clear and graphic illustration of some of the continuing issues relating to causation as I see it. And having made those points, I'm now going to hand back to Lee to ask him about the outstanding issues in relation to aggregation. Lee.
Well, thank you, Michael. It's always fun to have a look at aggregation, because I think we can all see as you look at it exactly how it's going to determine effectively how much is going to be either recovered or paid out in damages. One might almost subtitle this section of the webinar, "Show Me the Money." Just to remind everybody, aggregation, what that is, typically policies will allow or provide for claims arising out of the same facts or based on the same events or originating cause to be aggregated together, so treated as a single loss. And it's important to remember that this is something which can either help or hurt either side. So from a policyholder's point of view, if you've got a series of small claims being viewed as a single claim, then the total loss is likely to exceed any deductible payable. So what it means is that because you're adding them all together, the insurers are going to have to start paying out on the indemnity. Whereas, of course, if each of these claims were treated separately, they weren't aggregated, then, of course, the policyholder is going to have to pay a deductible in respect of each claim. However, there is a but, which is that if you've got a series of claims treated as a single claim because they're aggregated together, and you've also got, as you almost invariably do have, a limit in the policy for each claim, then of course you're very quickly going to exceed the limit of the liability available under the policy. So what is outstanding then in relation to aggregation? Well, Supreme Court held, as has been said already, that each case of illness sustained by a person as a result of COVID-19 is a separate occurrence. And in principle, that's pretty helpful for the policyholders to demonstrate that the insuring clause is triggered. But the sort of things that need to be looked at and thought about and are wide open and are going to have an enormous impact on the quantum that's going to be recovered in any given case is, to my mind at least, as follows. Number one, what is the aggravating event or occurrence or cause said to be in respect of claims arising out of the COVID-19 pandemic? Secondly, this is a global pandemic. Are we going to treat all losses and all claims as part and parcel of the same pandemic? What about the different variants? What about if we've got losses and illnesses in one variant? What about the other? Is it the disease that we're talking about here, or the government's response to it, such as closing businesses or imposing restrictions? What about the impact of other governments' responses? Countries we know might be on the green list, for example, as far as the UK is concerned, but that country might say, well, Brits can't come in. That's going to have an impact. That's a restriction that's going to have an impact on British businesses as well. So in summary, I'm conscious of the time, there's obviously an awful lot to consider in relation to aggregation. The starting point, of course, for aggregation is proving the manifestation of COVID-19. And in relation to that, I'll hand back to Celso. Celso, what does the latest FCA guidance say about proving manifestation?
Yes, Lee, thank you. The FCA, guidance that was issued on 3rd of March 2020 is entitled Final Guidance Business Interruption Insurance Test Case Proving the Presence of Coronavirus COVID-19. And it will have effect until 31st January 2022. But the guidance itself says that it does not prevent policyholders using other sources of evidence or putting forward their own arguments regarding the sources of evidence. And it goes on to explain how what are all the government and non-government sources which may be used by policyholders to prove the presence of COVID-19 in a certain area or in certain vicinity or in any as applicable to any specific different type of extension. And that will be important for policyholders in the future to prove their losses. But we will have to see what the declarations will say. They were promised during the month of May. We haven't seen them yet. There is this very important issue of causation that is exemplified in paragraph 22(3)(c) of the draft declarations, as Michael just explained. And there are also new cases which have been starting and have just started now in the commercial court. The case of Everat and Aviva, which is a case of a claim under prevention of access clause in the policy, and the policyholder claims on the basis of a reduction in the efficiency of work due to the lack of availability of the facilities in their premises. And it is a law firm, and that's the basis of the claim. And of course, we didn't have time to go through all the other recent cases. The Irish High Court case, which is on hypertrust and FBD insurance, which is also on non-damage extensions, and the two recent High Court decisions on physical damage based extensions, the TKC London and Allianz case, and the Rockcliffe Hall Limited and Travellers Insurance case, which will also be relevant in the future. But I will pass it back on to Michael, because we may have enough time for one question, perhaps, Michael.
Thank you very much, Celso. Yes, indeed, we do. And I'm going to take a question from Professor Lisa Short, who makes the point that, well, pandemics were known about. They've been known about for a long time, and the risk has been known about for at least 15 years. So it's been on people's radars. What was the duty on insurers to warn in those circumstances? And also linking on to that, looking prospectively and looking forward, given these policies are so exceedingly complex already, what confidence can a business obtaining business interruption insurance have in relation to getting value for money, or indeed any effective cover at all, perhaps? So that's not in Professor Short's question. So duty to warn and value for money. Celso, any thoughts on that?
Well, very broad questions, the two questions. I would say that as Lord Briggs remarks in the judgment, in the concurring judgment, they are very clear in his surprise by how long it has taken the insurers to agree that there were covered losses, and that it's taken so long with the insurers fighting those extensions, and he expresses his displeasure at the attitude that was taken by insurers. I think that the crucial killer point, as I mentioned before, in the decision of the Supreme Court, is that it must have been contemplated by the parties and by insurers that these diseases would go outside the radius. If so, then for insurers to turn back and say, because the notifiable diseases spread outside the radius, now there is no longer coverage. if you put it only on those terms, it shows how surprising it is that the FCA had to take the case to court in the first place. That I think I answered both questions in one. So what do you think, Lee? Do you have any comments on this?
Well, Celso, as you know, I think you and I discussed this. I should say I'm with Lisa on this, but you and I discussed this a couple of weeks ago, and I gave my opinion, and you told me that was, and I quote, heretical. I agree. Agree with Lisa. I think that these, although these policies and the wordings have been around for a very long time, I think they are totally unfit for purpose. I think if you look at it from the point of view of a business and a policy holder, some of them at least, these wordings make no sense and don't really capture what would be of concern to somebody who wants to take out a policy. So, for example, we were joking a couple of weeks ago about if the three of us had some sort of restaurant in Padstow or something, and there was COVID coming down the country, passing from Scotland through Manchester, if at that point in Padstow restrictions were imposed, why would we care if whether or not there was actually an instance of the disease within a 25-mile radius of our restaurant? We would be saying, but it doesn't matter. What we're concerned with here is not where the disease is, but what's being restricted. But of course, that's how these policies read. So I agree with you, Lisa. I think some of them at least are not right. In terms of what duty they have to warn, I think that's probably a tricky one, because they would probably say, well, the policies were there, you could read them. And actually, a lot of these difficulties, it's not that there is any real, in my view, difficulty about how to interpret them. I think it's more that when the judges read them and realised what they said, what they've done, and I think the word they've used in the judgment is manipulate. They've had to manipulate the language to bring about a result that they think is just. I think as far as the future is concerned, to the final part of your question, I think the reality is if pandemics, as we've seen, are going to be a real part of our life for the future, then on the one hand, given what we've seen now, having all lived through it 15 months, what the effects are going to be, number one, are insurers really going to want to insure against that? Because when it does happen, it's going to be it's catastrophic if they have to pay out. And what's the price of that really going to be? And is it going to be worth it? So to go back to Michael's point, how are you going to get value for money? Anyway, in summary, that's my view. I'm with Lisa.
Well, Lee, Celso, thank you very much. I'm going to exercise the prerogative right of guillotine at this point. A, to save Lee from being a heretic, and B, to save us all from hunger pangs of not being able to get down to Rick Stein's restaurant in Padstow for the last 18 months. In conclusion, Lee talked about this being a fiendishly complex or complicated litigation. He's absolutely right. And of course, that feeds through to two challenges. One is a fiendishly difficult challenge for us to fit in the essentials into an hour-long webinar, and my apologies for going 3 minutes over. It's also, of course, a fiendishly challenging exercise for you to formulate questions on the hoof. So I'm acutely aware that there may be aspects over which we have gone quickly, or there may be aspects to which we only gave limited analysis. Do therefore feel free to contact us individually or through the clerks with further questions and comments. We'd appreciate both comments and questions, which we'll endeavour to deal with. It only remains for me now, on behalf of Celso and Lee, to thank you all for joining us. We hope that we've helped you pick your way through this very important case, so far as it has reached. Because remember that the repercussions are going to be felt for months, years, possibly stretching a point, but even decades in the future, as 370,000 odd policyholders work out the implications of the legal principles identified by the Supreme Court. Thank you all very much indeed.